I thought I'd do is just make some opening statements that set the historical basis for why we're here today and how it developed, setting the stage for the hearing this afternoon. The matter before the court today is based on a two-phase proceeding. At the time the case was commenced, there was an initial plea of not guilty to the charge in the original information. Then there was a second plea of not guilty by reason of mental disease or defect. The matter was set for a jury trial on both of those pleas. On August 21, 2017, Ms. Weier entered a plea of guilty to the charge in the amended information, which was attempted second-degree intentional homicide, party to the crime with a dangerous weapon. The phase on the not guilty plea by reason of mental disease or defect would continue on to a jury trial. The maximum sentence on the amended charge of the second-degree attempted homicide is 30 years imprisonment, which breaks down to 20 years of initial confinement, 10 years of extended supervision. The dangerous weapon enhancer constitutes an additional 5 years of confinement. Thus, the maximum sentence on the criminal charge is 35 years of imprisonment, meaning 25 years of initial confinement and 10 years of extended supervision. Based upon the plea that was entered to the attempted second-degree homicide charge, the circumstances after the plea, at the time of the plea, were as follows, and both the state and the defense, Ms. Weier, agreed to these circumstances. If the not guilty by reason of mental disease trial resulted in a verdict not in Ms. Weier's favor, she would be sentenced on the state's recommendation on the criminal charge of 20 years imprisonment, meaning 10 years initial confinement, 10 years extended supervision. If on the jury trial for the NGI plea, the jury found Ms. Weier was not guilty by reason of mental disease or defect, then the case proceeds on that verdict. The state would, at the sentencing hearing on that portion of the case, agreed to that the commitment, and Ms. Weier agreed to this as well, that the commitment would be to institutional care and that she would not seek conditional release until July 1, 2020. That was the basis of going through to the trial, and ultimately the jury trial came back in the not guilty by reason of mental disease or defect phase and found that she was not guilty by reason of mental disease or defect. In doing that, the jury answered two questions in the affirmative. First question was, at the time the crime was committed, did the defendant have a mental disease or defect? The jury said yes. The jury also found affirmatively that as a result of the mental disease or defect, that Ms. Weier lacked substantial capacity either to appreciate the wrongfulness of the conduct or to conform her conduct to the requirements of law. So that's the basis that brings us here today for a sentencing on the commitment portion of the case. From that standpoint, does the state have anything to comment upon or state with regard to the sentence?
I think what you stated was correct and accurate, Your Honor.
All right, thank you. Does the defense agree with my comments?
Yes, sir.
All right. Then does the state wish to make any statements as to the sentence?
Yes, Your Honor, thank you. As you just pointed out, in return for the amendment, the agreement is that the defendant will agree to institutional care not to seek conditional release until July 1st of 2020, which really, and in terms of the institutional care, as you know, because you have in front of you, the predispositional investigation also agrees that institutional care is appropriate. So I don't think there's much of an issue there. The only real issue that's left remaining is how long should the commitment be? As you know, the maximum commitment is the maximum period for which she could be confined, so it's 25 years. And that would date back to the date on which she was taken into custody, which is the date of violation in this matter, so back to May of 2014. So then we'd be looking forward to 25 years, or looking forward, 25 years from that date would be the maximum term of commitment. You have received a victim impact statement from the victim's mother, Stacy. I can tell you that No one from the victim's family wishes to orally address the court at this time. They're all relying. They believe that Stacy's statement is accurate and accurately reflects their feelings also. So it's, even though it's signed by Stacy, it's more of a family-wide victim impact statement, I guess is the best way to put it. So then, as I said, we're left with the question of how long should the commitment be. The state believes that the maximum commitment of 25 years is appropriate. That would take us to 2039 at a point in time when the defendant would be 37 years of age. I guess my first thought is that considering the nature and gravity of this offense, being supervised until the age 37 is not all that long, given all the facts and circumstances here. It may be a long time in some respects, but it's not a long time in terms of the fact that Payton is looking at a lifetime of scars and psychological scarring, physical scarring, that she's going to have to deal with. So saying that 25 years is a long time pales in comparison to that. As you know from Stacy's letter to the court, Payton still suffers. She can't leave her drapes open. She can't leave her windows unlocked. This still affects her. But yet in spite of that, and in spite of her young age, she believes, which is, as was noted in that statement, and why the reason we agreed to this plea agreement, she believes that Anissa needs institutional care. Well, I don't know, frankly, how much time Ms. McMahon is going to argue for. State's thoughts on this is real simple. The maximum commitment, considering the lifetime of suffering that Payton looks forward to, will help her to derive a modicum of solace, knowing that at least for those 25 years, or what's left of those 25 years, that someone will be looking over Anissa's shoulder so that she doesn't have to worry that Anissa is looking over her shoulder. Frankly, I think it makes sense. I understand, because it's come up over and over, this argument about the juvenile brain and how it's not formed, and et cetera. But the fact of the matter is, we don't know that, in effect, Anissa is going to age out of this type of behavior, which I assume is part and parcel of an argument for less than the maximum commitment, is that, well, you know, once she gets that mature adult brain, this won't be an issue. We don't know that. What we do know is what she did now. We do know that she was susceptible to a shared delusion. We have no way of saying whether she's not susceptible to a shared delusion in the future, whether that be 3 years from now, 22 years from now. The fact of the matter is, Judge, we believe that the only real that I can think of, once at a certain point, assuming for the sake of argument that Anissa is doing better, she's going to be released from unconditional release at some point. If she's doing better, her supervision will do nothing more than making sure that she continues to comply with her treatment recommendations and making sure that she's not backsliding. The state doesn't see how that could be a bad thing, Your Honor. And in fact, if she's not doing well, which would be an argument, I guess, we don't want her locked up for 25 years, but if she's not doing well, that's exactly why she should be locked up for 25 years. So really, if she's doing well, this shouldn't be a big problem. And if she's not doing well, then she absolutely should be. She would be a danger then to herself or others, which is exactly why she should be locked up for 25 years in an institution. And I probably shouldn't use the word locked up, but I think we all know what I'm talking about. But if she's having problems, she needs care. If she's not having problems, this commitment will be very easy for her. She'll just simply prove to her supervising agent, that she's doing well, that she's doing the things that are required of her, and that she's not having any problems. If she's not doing well, as I said, that supervision will become important, both for the victim as well as for the community, and as well as the defendant. Because if she's not doing well, that would mean she needs help. And the only way we can ensure that she gets that help through this case is the maximum commitment. So we're asking that you impose 25 years of commitment in this case. And that's all I had, Your Honor.
What position do you take on medication?
Your Honor, the state's position at this moment is I don't know that. Well, straight. I believe that if she needs medication, if we're going to see her improve, if we're going to see her hopefully get released at some point down the road, that she would have to take that medication. So the state believes the court should order that she be required to take all medications that are required of her.
Thank you. Then Attorney McMahon, how do you wish to proceed?
Your Honor, I have some statements from the family that we've recorded. I would like to play those first, if the court would allow me.
All right. Now, are the when you play them, are they videos or are they?
It's a video, sir.
All right.
And I have, if the court wishes, a copy of it on a flash drive.
Well, before we start, then we should have the flash drive then filed with the court.
Certainly.
And that'll become an exhibit. As an officer of the court, you're representing that the flash drive contains a true and accurate copy of what you're playing in court.
Yes, sir.
All right. Now, on that basis, when we do something like this, the court reporter need not take the transcript down. We rely then upon the true record of wording what's said then on the video. Very good. You can proceed.
When we first started going there, she was a little girl. She was 12.
Now, excuse me.
She had no concept
We have to
of how
identify who this
serious
is.
this matter was.
Anissa's grandfather.
She would talk about
Well,
what
let's
she was
stop it.
going to dress up for as Halloween costumes.
Now, we have to identify who is the speaker, and perhaps you should start from the beginning then.
What age?
And this will, of course, be on the record.
The first speaker will be John Weier, same spelling as Ms. Weier, her grandfather. Also present in most of the scenes with him will be his wife, Melody, I'm sorry, a little nervous. Also speaking will be William Weier, father of Anissa, and Sarah Weier, sister of Anissa.
So what we should do then, just to be sure that our record's clear, that when the senior Mr. Weier is complete, and then the younger Mr. Weier testifies, we should have it. You should state that.
The problem, Your Honor, is
It's a continuum.
it's a continuum.
All right. So the three people speaking on a video, that's a continuum, and you've identified who
Four
they are.
people. Sarah Weier.
Four
as
people.
well.
All right. All right. Very good. Proceed.
And where she was going to be trick-or-treating that year. It was very difficult to sit there knowing that she wasn't going anywhere.
When she would first come in to the room, she would be happy to see us, but there were times during our conversations where she would look almost blank. I think that she probably was thinking, I wonder what my grandparents think of me now. There have been times when she said, I don't know why I would have done this. I can't figure it out. And that would bother her an awful lot.
She says, I take this one day at a time. That's how I get through it. I keep myself busy with my schoolwork. I keep myself busy with helping with whatever I can do.
She's almost taken on this role of pod mommy, as some people call her. You know, she knows how things function there. She has helped other kids learn the day-to-day routine.
I'll use the term more like a teacher's aide now, where she's been through these courses, she knows, and she's very instrumental in helping other students with their schoolwork and their learning.
She advises other kids, or sometimes counsels other kids when they're having a bad day, trying to give them different perspective. She's very good at letting people know that you know, there's light at the end of your tunnel, so don't get down, don't let juvenile detention define who you are.
I think this experience with her will give her an inside path to others who will need this kind of guidance.
Because of her experiences in West Bend, she's talked about going to school and becoming an advocate for children in her situation. She was taking online courses while in West Bend. She read, she did the work, she learned, she got through it, she got a good grade, and she wants to continue that. She wants to get her high school diploma. She wants to go on to college.
She goes, someday I want to get married. I want to find a guy that loves me and I love him. And I want to get married and have kids. And she goes, and then I think to myself, do you think that's going to work? Will my kids disown me if they find out what I did? Will my husband leave me?
All the psychiatrists and psychologists who testified had said that the chance of recidivism is nil.
3 of the doctors that testified all told the court that they feel, based on independent reports, that Anissa poses little to no threat to society, and her treatment would be best served with probably 2 years of talk therapy.
She's grown mentally and physically in the last almost 4 years. She knows what she did was wrong. I hope with the judge's sentencing of Anissa, he takes into consideration what he's learned in the last 3.5 years.
She will have had time to talk through what's been going on in her head and try to get some sense of why she allowed herself to get involved in this situation.
I know for a fact that she wants to come home, and I know that she's tired of sitting, but I know that she knows that she needs the help, and I know that she's okay getting the help. I miss having her around because it's just, she's got a really good energy. She's a good person, like deep down, honestly, she really is. Every time I talk to her, she's just always got this like light in her face, and she's just so happy. Now she's counting down the days until she can come home, because that's like one of the main things that's keeping her afloat.
Every day of our lives, we think about, why did this happen? Is there anything we could have done?
I think about them every day. I think about how they're doing. I think about their opinions of Christy and I as parents. I think about their opinions of Anissa. I hope that they can find it in themselves to see that Anissa is a good person and accept the apologies from the family for everything that all of the families involved in this tragedy have gone through over the last 3.5 years.
Memorial Day 2014 is a day not one of the families involved in this tragedy will ever forget. I cannot fathom the shock, fear, and anger that the Leutner family experienced that day. To send one's child off to a sleepover with friends only to have her attacked is something no parent should have to experience. I would like to offer my heartfelt apologies to the Leutner family for having this thrust upon them. Thankfully, Payton survived. It's something we gotta live with the rest of our lives. It'll never go away. But seeing her with the attitude she has and how upbeat she is and making the best of this situation helps us to get through this ordeal also. When we first started going there, she was
Mrs. Weier was unable to make the filming, and I don't know if she has anything she wishes to add.
I didn't hear what she said.
I agree with the family's statements.
All right, thank you. Appreciate that you're here. Thank you.
I understand what Mr. Osborne has suggested to the court. And had we dealt with a fully formed individual who had involved themselves as a party to a crime in this stabbing, I could understand that as the court sentence. But we're dealing with someone who was 12 at the time. What he's asking for, in essence, Your Honor, is for you to commit her for 2 times as long as she had been alive at the time this happened, plus a year. To me, that doesn't make sense. And perhaps it's because I also work, as Your Honor has at times, in the mental health portion of our court system. So I'm aware that if there is any evidence of future dangerousness when one nears the end of an NGI commitment, that there are options available to secure treatment, to require medication, to require hospitalization. So I don't share the fears Mr. Osborne has, and I think in our country we see any deprivation of liberty, whether it is for a meritorious purpose such as treatment, or simply for punishment. We don't do that without reason and without measure. And one of the important reasons behind limiting the amount of time one controls a person is, frankly, the other persons to whom you expose them. The evidence-based practices that have become common in our criminal justice system have come over from the human sciences because of important information, like the more you expose someone to more seriously criminal individuals, the more likely you are to harm that person and harm their behavior, not help it. That's why in criminal cases, probation is the presumptive in the beginning. And that's why our probation departments have begun dividing up who comes on what day to their office to avoid exposing low-risk offenders to high-risk offenders. Because as our mothers told us, it's not you I don't trust, it's your friends sometimes, and the choices you make when you're around them. The reality is, Anissa is going to be in a hospital setting for quite some time. And when the state asked us to stipulate to that, when within the statutes there are provisions for people seeking release and is supposed to be based upon doctor recommendations. Our young client was the one who said, no, they're right. I need that. She talked about how she had been away from normal society for so long that when her parents were allowed to bring a treat in to a visit that required the use of a fork, they had to teach her how to use it again. Because in secure detention, that's not a utensil they have access to. When you look at that, this child sat there and explained to us that she needed help learning not only to deal with the nightmares that don't allow her to sleep, with the fears and the concerns she has about, could I ever do this again? What do I need to do to make sure that nothing like this ever happens again? She felt she needed that time in the hospital. Your Honor has perhaps more information about this young woman than most persons who will ever come in front of you or any other judge, given the reverse waiver hearing, the competency evaluations, the Miranda Goodchild hearings, looking at both her functional abilities, her intellectual abilities, her mental health issues, and her behavior while maintained in a secure detention facility without medication for 1,301 days now. Many children slack off.
How many days did you say?
1,301 if you count today.
All right, thank you.
I noted that one of the media outlets reflected that my client had developed quite a sense of humor when you had asked her about school one time, and she informed you quite proudly that she went to school every day. The court is aware, and those of us who work with children who are incarcerated know that sometimes, depending on where you are, if you're incarcerated and you refuse to go to school, it counts as a mark against you, but they don't force you to go. She chose to go because school is important to her, because learning is important to her, and she knows it's important to the court. She, when trying to figure out where her life will take her from now, she knew that there were two options. One would be a hospital, and she knew that Winnebago, because she discussed it with us, was where generally females are sent on NGI, or Copper Lake, until the adult system. She researched and found that while she was now doing online schooling at West Bend, and they put that program in place so that she could expand her abilities to learn, she also learned that neither place uses computer schooling. So she worked with her teachers to create a curriculum that would transfer no matter where she was going, because she wants to be future focused and she wants to excel at whatever the court asks of her. The statements that her father made about the things Anissa wants to do now are things that Mr. Smith and I heard as time went on, as Anissa was in secure detention and saw some things that troubled her. She was very thankful, as were her family, for the professionalism and really the kindness of the staff, both at our secure detention facility and at the West Bend secure detention facility. She jokingly refers to the staff there as her step-parents, because for 3.5 years, in essence, they've been in loco parentis. But she saw that many children come into secure detention who, in her opinion, didn't need to be there. Children who were placed there because there was no place else to put them. Because as children grow older in our juvenile system, it's hard to find a foster home that wants to take them. And until that is found, sometimes that was the only option. It bothered her a lot. She talked to Mr. Smith and me about how she wished that this wouldn't make it so that she couldn't someday be either a foster parent or run a group home for children who had a run history or had a delinquency that made it so that foster homes didn't want to take them, because she had learned, getting to know these children during the short stays they had, that they were good children. They just needed someone to believe in them and someone to have their back. That troubled her a lot. It still does. I really think it troubles a lot of us who work in the juvenile court system. But to have this child who was facing so much on her own see how unfair that was to other people, that was impressive to me. And it also reflected a change in who she wanted to be and what she wanted to do when she was older. She did a little pamphlet when she was, I believe, in 4th grade. She was 10 years old when she did this. It's called My Life. And I have a copy for the state and for the court. Simply because it gives you a picture of Anissa Weier 2 years before this happened. She could have been anyone's child. In the end, she talked about her future, the last page of it. It was going to go like this. 10 years from now, I'll be 20 and training to be a zoologist, parentheses, person that works at a zoo, close parentheses. In 20 years, I'll be 30 and have a husband and a big lazy dog. In 30 years, I'll be 40 and be a zoologist until I retire. That's my future. Well, many of us have changed what we wanted to be from the time we were 10. Some of what Ani wanted for herself, still the same. And some of it has changed. She wants to give back and help kids. Still, as the court knows from all of the reports you've received, is worried about endangered species, climate change, things that affect the planet. But she knows before she can do any of that, she needs to seek help and make herself the healthiest person she can be. Your Honor, I think if the court is looking at what makes sense, when Your Honor was making the order at the end of, after the arguments at the reverse waiver hearing, you focused on what we knew about brain development, what we've learned over time, and that generally between 21 and 25, we have a very good picture of who this person is as an adult. 21 to 22, if you're a female who hasn't experienced significant trauma and mental health. Anissa's participation in the stabbing of Payton, as well as the time that she has spent taken from her family and separated from them physically, would qualify in psychiatric terms as trauma that can affect the maturation process. In some ways, it's made her much more mature than a lot of children, but in many ways, it's left her still 12 years old, not having had the formative experiences of high school that other children have. So there's sort of a mix there. I don't think, Your Honor, that we need to look at committing this child beyond their 25th birthday. I think that is what makes sense here. That would allow a period of time at the hospital and then time on extended release if it were appropriate. And that would be up to the doctors. I don't believe within the report that the doctors opined that Anissa was not competent to make her decisions regarding medication. I think that's a decision we should leave in the hands of the hospital. If they feel that she needs to take medicine and she's refusing it, they will seek an order. The court knows that, I know that. We have a young girl who's been on this earth since November 10th of 2001. I'm not really good with numbers, but I like when I can quantify something. That's 5,885 days, 1,301 of which have been spent in West Bend Secure Detention. She's spent almost a quarter of the life that she's lived in custody. So it's time to move her to the hospital. And it's time to let her move forward. But I do not think we need to hold her twice the length of the time that she had been on this earth before this terrible incident. I want to thank Mrs. Leutner for her letter. The terrible pain it expresses for their family. I know that my client is beyond sorry for. And she knows that she can never fix what happened. She can never change what happened, but she can work to make sure she's the best person that she can be to honor Payton. I particularly made sure to share with Anissa the last paragraph, the fact that Payton wanted her to go to the hospital. That the reason the family was willing to accept what we had talked about as a plea deal was because their daughter wanted these two girls, not just Anissa, but Morgan too, to go to the hospital and get help. It tells an awful lot about what a wonderful child Payton is, and is something that I think was probably one of the kindest things my client has heard in 3.5 years. It made her cry, but it, I think, was healthy and healing for her to be able to hear that that was what Payton wanted. And she knows that it is unlikely that Payton would ever want to have contact with her again, and so she will stay away from her She has in the past, after we had talked with her about some of the options the juvenile system offers, one of which is oftentimes victim offender mediation, that's been used also in adult systems at times, if the Leutner family ever wanted that and felt it would be healthy for Payton, she needs that or wants that. Anissa is more than willing to participate in that. She knows it's not likely, but if that was something that would help Payton, she would do it. So, Your Honor, I am asking you to consider the amount of time already that she has had in custody. Mr. Osborne says, well, we don't know who she is, who she's going to be. But we know for 3.5 years in very difficult circumstances that she has managed to follow the rules and not allow herself to be influenced by the other persons that she was placed with for a long period of time. She has worked hard and done what was expected of her in a situation that very few children have ever been in, being in custody that long. Now, there are children who go to Lincoln Hills or Copper Lake and may be there for that length of time, if they have access to the outdoors. It was only after about 260 days, maybe longer, when Your Honor authorized the visits here in Waukesha that Anissa had any access to natural light. As the court may recall from the testimony at the reverse waiver hearing from Nicole Sakek, who runs the West Bend Secure Detention Facility, their natural light requirement is met by a frosted skylight in the day room. The only glimpses of the outside Anissa had were on trips to court until she was allowed to go shoot baskets in the courtyard of our secure detention facility. That same amount of time, from the date of May 31st, 2014, until our first visit at the Juvenile Detention Center, were also time spent without physical contact with her parents and without any contact with her older sister, her older brother, or her younger brother, because they were not allowed on the visitors list because they limited to parents and grandparents. When we look at things that in the criminal system would be seen as indicators that the person is likely to respond well to supervision and to respond well to societal expectations, one of the primary things we look at is support. Is there a pro-social family behind this child? And the answer is yes. Not only are they hardworking people, they have spent, I believe, every day. There may have been 1 or 2 days that were missed, but every day since May 31st of 2014, they set up a visitation schedule, and between her mother, her father, and her grandparents who spoke, they visited her. They were careful to avoid school hours because Anissa didn't want to be taken out of her classes. But that sort of devotion and that sort of willingness to stand with the child, no matter what, I think is another thing the court should take into consideration when determining the length of time needed on a commitment. Her family, knowing now what they know, knowing that she has a disorder, and knowing that particularly with a delusional disorder, it was Dr. Kavanaugh at the reverse waiver hearings testified that given the lengths a person will go to protect the delusional structure, that they would not have notified parents. They wouldn't have done things to show them what was happening. They know this now, and they can watch. And they will. And I think they will probably be far more and long-standing support for Anissa to keep her on the right path. So, Your Honor, given how long she was spent in custody, how young she was at the time, the remorse that she has shown throughout this, I would ask you to consider allowing the commitment to end on the 25th birthday. I think that makes sense. and I'm hoping that you will do that.
All right, thank you. I appreciate your comments. Then, Ms. Weier, do you want to say anything?
I just want everyone involved in this to know that I do hold myself accountable for this, and that I will do whatever I have to do to make sure that I don't get any sort of delusion or whatever again. And I want everybody involved to know that I deeply regret everything that happened that day, and that I know that nothing I say is going to make this right, Your Honor, and nothing I say is going to fix what I broke. I'm just hoping that by holding myself somewhat accountable and making myself responsible for what I took part in that day, that I can be responsible and make sure this doesn't happen again. I'm never going to let this happen again. I'll do whatever I have to do to make sure that this doesn't happen. And I know you've heard that before, and you're probably going to hear it again, but it's the truth. And I'm sorry.
And well, thank you for your comments. I appreciate them. Anything further from the state?
No, Your Honor, my comments stand. I don't think that, so they're same as Ms. Camp, but I don't think she said it, I really need to comment. Other than the one thought I did have is that 25 is not a magic number in this whole case. I say we should go till 25. Take an average day when the juvenile brain is fully developed, but it's just a day. So I think, though, that the supervision that would go to age 37 is much more appropriate for all the reasons that I mentioned.
All right, thank you. Then Ms. McMahon, anything further?
No, Your Honor.
All right, thank you. As was noted, the court did receive the letter from Payton's mother, Stacy Leutner, and I've read that and been distributed to the parties, so I'm aware of its content. The court also, at the time of the jury verdict on September 15th, I did order a predispositional report from through the statutory process, and Wisconsin Correctional Service is the one that prepares that report, and they did submit the report on November 3rd. It's a rather detailed report, very thorough, at least appears thorough. It's 7 pages in length, and it discusses the Ms. Weier's current status or current situation, things that had happened at the West Bend Detention Center, and what their recommendation is and how the case should proceed from their standpoint. So I've read that, and the parties have each had that as well. The court follows the statute. This type of case is in court under section 971.17 and in of the Wisconsin statutes, and specifically when the court arrives at determining the commitment, the court looks at 971.17 sub 3 sub a, which gives the court the authority to issue the commitment and gives the court the authority to and criteria that the court looks at and thinks through in deciding what the commitment should be. So I've reviewed that statute, and I have that in mind as I review the case today. As has been discussed earlier, the nature of this case is that the maximum period of the commitment is the maximum period of confinement that's available under the criminal charge. And as I indicated earlier, that's 25 years. And that's why that number has been discussed by the state and presented by the court in my initial comments. There was, as I indicated initially, as part of the plea, and when there's a plea is entered, it's a plea negotiation in a case, that plea agreement is presented to the court. The court has to approve the plea agreement, but the court's never part of the agreement, so I'm not bound by it. But there are parts of the agreement that do bind the defendant in this case. And one is that there was an agreement that she would not seek conditional release for a period of time. that she agreed that the initial commitment would be institutional care. And I'm satisfied in reviewing all of the documents at institutional care, looking at reports, what I know about the case, listening to the comments, that institutional care is the appropriate type of commitment. So I recognize that Ms. Weier has agreed to that, but I also find by clear and convincing evidence that the conditional release of Ms. Weier would pose a significant risk of bodily harm to herself and others. Thus, the commitment will be to institutional care. As part of that agreement, she also agreed to not seek conditional release, which is a way to be released from the commitment institutionally. It's not a release from the commitment itself, but it allows you to go out on the street, if you will, not to make that request for until July 1, 2020. Under the statute, someone who's committed under 971.17 can seek release every 6 months if they have the necessary reports and file that petition. So in their plea agreement, to which she would be bound, she has agreed not to seek that type of release until July 1, 2020. Now, looking at the circumstances of the case, it's in reviewing the matter, as I indicated, I have the courts in any kind of a criminal case, the court's concerned with what the impact is on the victim, the victim's family, and society as a whole. Criminal acts occur against people, sometimes property, but generally people. But there's always an impact in the community as well. It's really a broad impact that occurs. The letter received from Ms. Leutner describes very well the impact it's had on Payton and on their family. In some respects, and that type of impact, the nature of the impact, flows out to the community and impacts everyone really with what happened. The dynamics of this case are simply tragic. Young people involved in what started out as a good time turns into tragedy. Someone is almost killed. Just not a good situation, but that is what happened in this case. In recognizing the impact to Payton, the letter has been distributed and has actually appeared in the news. Parts of it were reported in the newspaper, and I believe on the television media as well. But there are aspects that really go to the nature of what happened that I think it's important that the court keeps in mind, because the court has to be cognizant of the nature of the crime that occurred in this case. The part of the letter states that, this is Ms. Leutner's letter, states the 19 stab wounds that Payton endured that day left 19 very visible scars on her arms, her legs, her hip, her torso, and her chest. The nearly 6-hour surgery and other medical treatments to repair her heart, diaphragm, liver, stomach, and pancreas left 6 more scars. 2 of these scars span from just below her neck to just below her belly button. It goes on to discuss some issues with regard to the scars, but then it talks about something that's almost a very practical result of those type of injuries, and that is shopping for homecoming dresses leaves only a few options because far too many dresses will show off her scars. Beach vacations are harsh reminders that swimsuits aren't made for young girls with 25 scars. So we have the physical injury, but then you got this other part of it that it's what always reminds Payton and her family, would remind others of what happened. The scarring and how to disclose it or shield yourself from it, shield others from it. The letter goes on to discuss Payton's wounds being far more than physical, beyond physical, and then discusses the emotional trauma, fear she has, difficulty she has as a result of what happened. Letter emphasizes that Payton, from one standpoint, from an outside casual observance, appears to have recovered well. She's back in school. She's gone to school activities. She's been actively involved in things. Letter points out that she's more reserved, she's more cautious, all of which isn't surprising when you look at what happened. Talks about impact to Payton's brother and what happened, his reaction to the talks about the impact, the marriage of Payton's parents. And then, as was Attorney McMahon noted as well in the last paragraph, Ms. Leutner talks about what brought him to today and what brought her to writing the letter. And it talks about, it says, the reasons for agreeing to accepting the plea deals for Morgan and Anissa. First, because we believed it was the best thing to do to ensure Payton would not have to testify. Traumatizing her further didn't seem worth it. It's a very practical result, but that's certainly true. Just as you walk down the street and somebody looks at your scars, to come back in and relive everything verbally would be traumatizing, and it would be a new injury to her and to the family and also to the community. And second, because Payton felt placement in a mental health facility was the best disposition for both girls. While Payton believes a mental health facility is the best place for Morgan and Anissa, she still fears for her safety. She still sleeps with her windows closed, locked, and with security latches engaged. She still refuses to open her curtains. So that's, I think a very, very emphatic statement of the impact to the victim, to the family, and in a sense, and how it reflects back on the rest of the community. That's a factor the court keeps in mind, is what was the nature of the offense and what happened. In the presentation today is that Ms. Weier, not just today, but in all other circumstances. I find her to be mature in her presence in court. I think she has empathy for what occurred. I do see remorse in what she said. You look at her coming up, growing up, undoubtedly a good family, doing well. The brochure that Ms. McMahon presented says a lot about a happy little girl of 10 years, as she wrote about her life. Undoubtedly, that's the same with Payton and her family, but with Ms. Weier, it's certainly reflective. She's had, as Payton has had, the Leutner family and friends have been here all of the time, and has the Weier family been here all of the time and showing support. So you have two young people that get involved in a tough, nasty situation that will impact everyone for a long time. I think what Ms. McMahon said about what happens when Ms. Weier is married, has kids, or her kids, how do people around her react to what she was involved in on May 31 of 2014. Those are long-standing, deep wounds that I doubt will ever heal. The same is true for the victim as it is for the perpetrator, for both of them. When the court looks at a sentence, or a commitment in this case, I look at what I've talked about, the impact on the parties, impact on the victim, impact on the defendant. I look at the nature of the offense. It's a critical part. To some extent, I've talked about that. In looking at the predispositional report from Wisconsin Community Services that wrote the report, I think Wisconsin Correctional Services earlier. That used to be their name. It is Wisconsin Community Services Incorporated. The writer presents really a really good background and detail on what happened, the planning for the offense. We have to, in addressing out what the offense was and forgetting about even who the victim is and who the defendant is, who the perpetrator was. This was, according to the report and according to the evidence that we have, this was an offense that was planned. The offense occurred on May 31, but the planning apparently started sometime in December of 2013 or January of 2014. So this wasn't that spur of the moment offense that all of a sudden people get excited and they do something that they regret. This is a planned offense. It was a planned murder. Can't forget that the effort in this case, the goal of this matter was to kill the victim. It wasn't to wound her, it was to kill her. And of course the report talks about the situation with Slender Man. It's really been much of the sort of the media focus of the case and the media drama of the case is what happened with Slender Man and how that had an impact on what happened with the offense. But the report goes into some detail about the planning and how everything came down the 30th and the 31st. What the report, and that's been in the news and been the subject of much discussion, but it's only something I have to keep in mind. And when I decide what the commitment has to be, I look at the nature of the offense, what happened. The planning part of it is important. The serious part of it, the serious nature of it, a planned murder by kids. Now, I can say a planned murder plan for months, and it sounds like I'm talking about some organized crime operation, but these were kids doing that. The impact is the same, but it's still got to keep in mind the age of the parties, and I certainly do when I reflect on what the best commitment is on Miss Weier's young age. In the report goes on to begins a review of the Miss Weier's current psychiatric emotional status, and does so by first looking at the three reports that were three expert witnesses that testified at the jury trial and their various opinions. The report goes on to look at Dr. Michael Caldwell, opined that Miss Weier was suffering from delusional disorder, persistent depressive disorder. Her delusional disorder was more likely by her underlying schizotypal disorder. Miss Weier exhibited a cohesive system of delusions about the existence of a supernatural evil things that would control the thoughts and actions of others and commonly kill children and their families. That certainly was part of the case and came out repeatedly about the delusion, the impact that the Slender Man character and process had on both Miss Weier as well as Miss Geyser. And then we go on, and the writer talks about Dr. Melissa Westendorf, who was another expert that the defense brought in, as to her view. She found that there was she shared the concept of the dual delusional disorder. Miss Weier's in that relationship between two people that Miss Weier is considered the submissive recipient of the shared psychotic disorder. Dr. Gregory Van Raybach testified as well as a third expert. He shared the opinion that Miss Weier suffered from a shared delusional disorder. He found and wrote that she became ensnared in a false belief that was constantly reinforced within her relationship with her friend, and could not at the time of the crime distinguish between those false beliefs and reality. So those are the reports that were part of the jury trial. They were formed the basis for the jury verdict in this case. But that's the psychological, psychiatric, mental health background that brings us here today. The significant, what I found of much of what I read in the report, I knew, and I knew from prior hearings. So there are parts of the report which were new, and to some extent startling about what has been going on and what the situation has been at the West Bend Detention Center. In a section titled Psychiatric History, of course, Miss Weier reported that she struggled with depression since around 10 to 11 years old when her parents were going through a divorce. For about the last year and a half, now that's the letter, this report was written in November, so it's going back to 2016. For the last year and a half, she's been meeting with a therapist from Waukesha County Health and Human Services. In therapy, they work on managing anxiety and practice breathing techniques. Ms. Weier denied ever hearing Slender Man talk to her and denied ever feeling like he was in control. She denied any history of auditory hallucinations. Then the report goes on. Reports confirm that Ms. Weier has been meeting with therapist from Waukesha County since May 20, 2016. At intake, Ms. Weier's primary complaints were related to having difficulty coping with her incarceration and guilt about her offense, difficulties in her relationship with her mother. Ms. Weier has worked with Ms. Weber on mindfulness techniques and dialectical behavior therapy. In December of 2016, Ms. Weier told Ms. Weber about having made a homemade Ouija board in the jail and that some evil spirits were let out. Ms. Weier believed that the evil spirits were pushing down on her bed at night, was worried that the spirits might kill her, and had difficulty sleeping, and had dreams in which God told her that Slender Man and the evil spirits were actually demons. To address this, the therapist planned to work with Ms. Weier on distinguishing the difference between reality and fantasy. However, since about January of 2017, it appears they did not continue to talk about Ms. Weier's superstitions and delusional beliefs, but instead focused on difficulties within her family. I'm concerned when I read that, one, that there is an opportunity for therapy and it didn't really take place about the big issue for us, and that's Slender Man and the attempted murder in this case. And that the Ouija board came into play. You know, that's a game in some respects, but in other situations is a very serious situation. That she was allowed to do that at that institution and allowed to have some other issues that will develop about what one could classify as delusional characters. She acknowledges that she believes that Slender Man is, in a part of the report, she told the writer as well as the therapist that she believes Slender Man is real, sees him as a demon, tries to address him in that fashion. The writer of the report ultimately recommends institutional placement and believes that and quote, the conditional release team recommends institutional placement for Ms. Weier and believes that she still poses a risk of harm to herself or others at this time. Under the shared delusional belief with her co-actor that Slender Man would harm her or her family if she did not carry out his wishes, Ms. Weier took part in the violent stabbing of a childhood friend. Ms. Weier continues to believe that Slender Man is real. She also stated that as recently as July 2017, she believed that an evil spirit was pushing down on her bed after the spirit had been let out of a homemade Ouija board and that she'd been playing with. She has continued to be easily influenced by peers. She has been convinced by another inmate who was a devil worshiper that her co-actor, meaning Ms. Geyser, is possessed. And the report goes on to discuss the comments by Dr. Raybeck, the Van Raybeck, from his November 2016 report, where he states, quote, "Today Anissa appears to be in full remission from the delusion, but is in need of treatment about its ramifications. She will need treatment concerning the genesis of the behavior itself, and the trauma and distress about attempting to take the life of another human being." Unfortunately, that's the end of the quote. Then the writer goes on to state, unfortunately, none of these issues have been addressed in any therapy length. Thus, she, meaning Ms. Weier, still exhibits some of the same characteristics that factored into her offense. The report continues that the team believes that placing Ms. Weier in an institution for an extended period of time would be beneficial to her without the distractions of a community setting and much less risk of harm to herself or others, and discusses a safe setting of a mental health hospital. In looking, I went through the report in detail because it has significant comments that certainly have an impact on what this case is about and what the commitment is about and what direction that that the commitment should take. It certainly looks at the nature of the offense, at the nature of the crime that occurred. It talks about the safety issues, and get a sense for the safety issues that are involved in a case such as this, and what the community has to do, and the legal system in this case has to do to ensure that based upon the nature of the jury verdict, that Ms. Weier has that opportunity to heal, become a safe member of the community, and function just as she wants to do in the future. There are a lot of roadblocks to Ms. Weier, most of which that Attorney McMahon talked about. It's going to be difficult for Ms. Weier to move ahead just in the long term. Even if she gets over the day-to-day issues, the long-term memories, just like they are for the victim, will always be there and have that impact. She has served a lot of time in custody, 1,301 days. It's a long time for many people, and especially somebody so young. It's a good portion of her life. But the court has to be concerned with looking at all of these things. What's the best for the community? Things may be what's best for the community may not be what's best for Anissa Weier. We have to be careful about that. The long-term impact of this case has to lead to a conclusion that it doesn't happen again. We don't have any repeat activities. As much as we can sit back and say, I will never do that again, and I think it's sincere, I'm not criticizing her for saying it, we don't know. There's enough history here, especially with what's most recently occurred at the detention center, as related in the report, that delusions still occur, and that type of, if you will, evil delusion is still out there, perhaps in another form, leads the court to be concerned about a short commitment period. I think the court has to look at one that's longer and has a more permanent impact in protection. There are other factors that the court looks at in determining commitment. If Ms. Weier is released, where does she live? How will she support herself? Those really don't have a direct impact on what we're talking about today. Have to have assurances that if she's medicated. Today she receives no medication that I know of, other than if she has a cold or some other issue. But from a psychiatric, psychological, mental health standpoint, she doesn't receive any medication. You have to be concerned that if there is medication in the past, in the future rather, that it's always available, and protections to be sure that that the medicine is taken. What are all of the arrangements for treatment, as well as medications? When I look at all of this and try and put all these circumstances together, and I weigh the youth of Ms. Weier, the naivety of her when the offense was committed, I look at the nature of the offense. I've talked about that, and I don't want to overemphasize the nature of the offense, but yet, if you think about it, it's almost like iron filings with a magnet. You can't really discuss this case with the disposition of it without looking at what happened. Then you have to look at what impact that has had on people, and what does the future hold. When I look at and read the report, the predispositional report, I'm very concerned about the near future, with comments about the Ouija board and the delusions and the demons. That tells me that Ms. Weier still has issues that we have to be concerned about. The recommendation from the state is that I commit her for 25 years. That's a good portion, good amount of time. I think it's twice how long she's been alive ultimately, from looking at the nature of the offense, a long time. The Attorney McMahon argues persuasively that the court should look at a shorter period of time and look at to age 25, which would be obviously 12 years less than the state talks about, but still a long period of time for someone to be supervised and watched. One of the concerns this court had when the court made the decision about whether the case should be turned to juvenile court or remain in the circuit court was that the juvenile court jurisdiction was short and would end, and we'd have no assurance of community protection after essentially age 18. That when keeping the case in the circuit court, which is where it is today, allowed the system to go forward as it has with this jury verdict, and allows for long-term supervision and control. Although the commitment is long that the state proposes, and that what Ms. McMahon proposes as well, both are long times within a system. The person that's committed has the ability to ask for conditional release as her system and as her mental health situation improves. There are many people out on our streets today that are released on that have conditional releases. They have mental health issues. They've been committed through the criminal process, not through Chapter 51, but through 971, and they're out on the street on a conditional release. They're watched, they're supervised, they go to work, they function, many of them raise families. So the long commitment isn't sort of being confined to the black hole of Calcutta for as many years as the commitment is. But it says supervision, it says control, it says monitoring. When I put that together into the mix, I'm satisfied that the maximum commitment is what's necessary in the case for all of the reasons that I talked about. I'm not going to go back and relive those circumstances, but I believe to maintain safety, to maintain protection to the community, to maintain protection for Payton so she has the resources of the community to assist, or rather for Ms. Weier, that she has the resources available to protect her in the future, be sure that it keeps her out of trouble if there's going to be trouble, and if it's not going to be trouble, that can be resolved through the system. But it gives the community assurance of safety and protection. It gives Ms. Weier that opportunity to, I think, to proceed and to become a functioning member of the community. The purpose of our legal system, in particular a process such as we're in today, isn't simply to put somebody away and not permit them to grow and to live and to adjust. I'm satisfied that Ms. Weier can do that. She will do it. But she has to do it keeping in mind, as I think she knows, of what happened and the community's perception of what happened. So I'm satisfied the 25-year commitment is appropriate. I'll order that. So ordered. There's a request for 1,301 days credit. Any objection to that?
No, Your Honor.
Don't want to wake anybody up, but
No.
no. All right. Then I'm going to order 1,301 days credit on the commitment. I raise the issue of medication as one of the issues I have to address that should be addressed at this fact. It must be addressed. The statute says I have to address the issue of medication. The state says I should order the medication. Ms. McMahon states that indicates that I should not. From Attorney McMahon's perspective, there is no medication in this case. There never has been.
Correct, Your Honor. And so no doctor has sat down with her and explained the benefits and detriments of medication and made a determination whether or not, as is required under our laws, whether she has the ability to make that decision herself. And until such time as that happens, I don't think we should order it. If the hospital needs that order, they are not shy about seeking it.
Any comments from the state?
No, Your Honor.
For those that don't know, in a situation such as this, if a person's prescribed medication and it's for their mental health and they don't take it, the court can order that they be compelled to take the medicine. That's the medication order. The statute says I have to review it at this time. As I indicated, there's never been medication administered in this case. There's no outstanding, if you will, controversy about the use of medication. So I'm not going to order a medication at this time. That it be administered against her consent at this time. It'll still may be administered. If there is an issue, the institution will bring it back. With that, then I commit Anissa Weier to the Department of Health Services for a period of 25 years, subject to the credit that I've provided, subject to the order that I'll issue. I'll order that she be transported to the Winnebago Mental Health Institute today.
Your Honor, I don't know that Winnebago Mental Health has an opening today. I tried to reach their intake unit to determine that. I spoke with Matt Ziegler, who did the report for WCS, indicated that generally what he has seen is there's approximately a week wait time. They're in part, I think, because they generally need to make sure that blood draws are done, things like that, to make sure that the person is medically stable to come into the hospital.
You may know more than I know on that topic. What I do know is that the court did speak with one of the officials at Wisconsin Community Services, and with the thought that that the court would at least follow the recommendation through the plea agreement that would be a commitment to Winnebago, that if it, regardless of the length, she'd have to be taken there. And we were told they would expect her today, and I think the sheriff is prepared to transport her there.
Okay.
Now, that doesn't mean I want Ms. Weier traveling about the state, because I know that's happened in the past. We've ordered people to go to Winnebago or other institutions. They get there and the institution won't take them. So we will fax the orders to Winnebago as soon as the hearing is complete, and we'll verify that it's appropriate. Do you want to meet with her family and her today?
If we could, Your Honor, I do have to run over to Branch 3 for a matter, but then I could join them over at the juvenile center.
Well, I'm going to order then that as an interim matter that Ms. Weier be transported to the juvenile center. She can meet with her family as she has in the past, and that she'll stay there till 4 o'clock. At 4 o'clock, then she'd be transported, and we'll verify what the location is.
And if Winnebago does not have the opening today, we had anticipated that she would go back to West Bend, and that's why West Bend didn't send all of her things with her today until she could be taken to Winnebago.
Now, they didn't bring all of her things with her?
No.
No, all right. Well, then maybe it's bad. Well, we'll verify with Winnebago what the approach is, and we'll take that. Otherwise, the order is that she be transported to the juvenile facility here to meet with her family and attorneys, and then by 4 o'clock leave to either return to West Bend or to go to Winnebago.
Thank you.
Now, you'll explain to Ms. Weier her appeal rights?
Yes, sir.
All right. With that, then, anything further from the state?
No, sir, thank you.
Anything further from Attorney McMahon?
Not at this time, sir.
All right. Well, thank you, everyone, for being here. Have a good day.
See you in a while.